Good morning and a very warm welcome from what is unfortunately a very wet England this morning. Thank you for joining our first IM Private Wealth collaboration between our family teams and our tax, trusts and estate team. For those of you who don't know me, I'm Claire Wiseman. I head up our family team in Birmingham, which is now 20 strong. And I'm delighted to be joined by Jenna Lucas, Mark Hans and Alex Ruffle. I'm particularly pleased to introduce to those of you who don't already know them, Mark and Jenna, who are our brand newly promoted partners, but both of whom, as many of you will know, have been working at a senior level in complex international cases for a number of years. So Jenna works mainly from our London office and she heads many of our international cases there. And particularly at the moment, Jenna's got a number of cases on in the Middle East and particularly Dubai. Mark works mainly from Birmingham. You may or may not have experience of our cases and our colleagues in Irwin Mitchell, but we do have international expertise in all our offices, which makes us quite unique. So it means that our international work isn't all being dealt with just from London. An interesting fact about Mark is that he's the youngest person ever to win the IAFL Young European Lawyer Award, which I think in my book makes you about 12 at the time, Mark. He's also a member of Reunite. Lastly, but certainly not least, my partner from London, Alex Ruffle, who's in our tax, trusts and estate team and has particular expertise in cross-border complex tax and trusts work. And thanks, Alex, for joining us this morning. I think that really showcases how important it is to have that holistic approach to international family law work, as you'll see when Alex comes on to talk about the tax and trusts cases that she's helped us with in recent months. We're pleased that so many of you have been able to join us across a number of countries, Ireland, Channel Islands, through Europe and even from Australia. So that's brilliant that you've been able to join us. We are recording the session, particularly for those Western colleagues who are hopefully still asleep, but also to share with you following the presentation. So what have we chosen to talk about this morning? We've chosen what we hope will be areas of interest and certainly the most topical cases and complex situations we're seeing in family law. We're going to cover children, prenups, the division of trusts and tax related issues. Because we've got such a diverse audience, we didn't want to concentrate on the case law and the evolution of the detail that we're experiencing. So we're going to talk more generally about legal principles, which will hopefully resonate with the diverse audience that we have today. We've already invited and have received some questions from you, so thank you for those, but please continue to submit any questions you'd like us to try and deal with through the Q&A function on your chat, and we'll attempt to answer those at the end of the session if we can, but we are keen to keep to a 9 AM end time if at all possible. So send those through, and as long as I don't crash the tech, we'll do what we can to address those. If we don't get to them, then we will send out some answers and some further communication at the end of the session. So without further ado, if we could move on to the questions. I'm going to start with a session on children, and I'm going to ask Jenna to answer the first question, please. So Jenna, in what circumstances can the Court of England and Wales be asked to exercise its jurisdiction in connection with the children of international families?
Good morning, everyone, and thank you for joining us today from all corners of the globe. So Claire, the general assumption is that the Court of England and Wales will only make welfare decisions in connection with a child where there's a dispute between parents if that child is habitually resident in the jurisdiction of England and Wales. In short, if they live here. That sounds simple enough, but living here in a conventional way is not the end of the means by which an international family can seek to have disputes relating to their children resolved by the court here. There are three things for practitioners advising parents of children who may not at first blush be habitually resident to think about, and that is whether there is a case on habitual residence, the parens patriae jurisdiction, the Family Law Act of 1986. So firstly, one needs to properly consider if there can be a potential to argue that a child is habitually resident here in a less obvious way. Habitual residence is a question of fact, which underpins the jurisdiction in international family law. And it's necessary to do a detailed analysis of the lives of international children to consider where they may be habitually resident at any one time. For example, we've successfully argued that a child's habitual residence here was established by way of their attending boarding school and spending exeat weekends and some holidays in a property here with a nanny, whilst the primary family home was in another jurisdiction. Equally, spending extended periods, such as summers here in a second home, or where a child is dividing their time between various countries, may give rise to a habitual residence in certain circumstances. Fortunately for me, the enormous topic of the law surrounding habitual residence is not one I'm going to wrestle with today, providing you with this overview. I'm going to primarily focus on children who are not considered to be habitually resident here. If it's not possible or likely that you'll be able to establish habitual residence for a child of an international family, you might still seek to persuade the court to hear proceedings in relation to the children where the children have never lived here, where there is a limited connection to the country. There are two grounds on which you might seek to rely on one of the following. Firstly, the applicant parent can seek to invoke the court's parens patriae jurisdiction to provide children who are British nationals with protection where there is no other protection which can be provided to them. It's essentially the court's ability to protect its citizens wherever they might be in the world. Limitations, boundaries and possibilities of the parens patriae jurisdiction is not one which the court has grappled with in any meaningful way yet. Practitioners really hoped they might in the case of Re B, which was a Supreme Court decision 2016. In that case, the Supreme Court did not need to determine the arguments in respect of the use of the court's inherent jurisdiction and parens patriae, having concluded that the appellant's case would succeed on the basis of habitual residence. But there was judicial comment that the inherent jurisdiction is not necessarily confined to exceptional circumstances, as might have been the thought at the time. This is again another huge topic capable of much legal and academic debate for another day. Secondly, and perhaps more conducive to many of the cases we see, where issues relating to children arise out of the breakdown of the parent's marriage, it's possible in those circumstances to issue proceedings in the usual way pursuant to the Family Law Act of 1986. That jurisdiction is established if there are connected proceedings already extant in this jurisdiction. And what that means in practice is usually that there are live divorce proceedings in this jurisdiction where both parties might live abroad. The link can be as tenuous as one party having a domicile here. That is a scenario which arises for us regularly. So when clients are doing their initial forum comparisons, we may contact many of you for advice as to their prospects in your jurisdiction, or indeed when you contact us for the vice versa advice. We need to be considering whether they would wish to elect or be in an advantageous position if proceedings relating to children were to be resolved here. For those who are interested, the relevant sections of the Family Law Act are section 2(1)(b) in combination with subsections 2(a) and 42. And this was considered and interpreted by the Court of Appeal in the 2019 case of Lachaud and Lachaud, where Lord Justice Moyland said that Mr. Justice Mostyn had been wrong to conclude that divorce proceedings were not connected proceedings for the purpose of issuing children proceedings under this statute. When you issue proceedings on this basis, section 2(a)(4) of the Family Law Act does permit the court to stay those proceedings on the basis of forum non conveniens, where a jurisdiction is established, but there is a more appropriate jurisdiction to resolve those issues before the court. Because the jurisdiction is established, the burden of proof sits on the person who wants the stay, which means that the parent responding to those proceedings has to persuade the court not to deal with the case in favour of it being resolved in another jurisdiction. The test which the court will apply arises out of a 1986 maritime case called Spiliada, and although the children's interests are a relevant concern for the court, they do not attract paramountcy status as they do in substantive proceedings. The court will consider a long list of factors, including the desirability of deciding issues in respect of the child's upbringing in the country of their habitual residence and the connections with the forum. And in my experience, when looking at that, the devil is really in the detail. The relative availability of each forum, including investigative and reporting systems, but in practice judges are going to be reluctant to assume that mechanisms for a fair trial are not available in the other jurisdiction. The availability of witnesses, evidence and expense of the proceedings, which is essentially a practical consideration of where the hearing should take place. Any prior agreement between the parties as to where litigation should be undertaken. The court will also look at the stage the proceedings have reached in the other jurisdiction. Are there even proceedings there yet? Will it give the parties an outcome anytime soon? The court's also going to consider principles of comity, recognition by our court of judicial decisions made by a court of a different authority or jurisdiction, and the prospects of success of each application. Does the substantive application have merit? If the court reaches the conclusion that the other forum is more appropriate on the facts of that individual case, in accordance with those factors, it should grant a stay, unless a more potent factor points the court in the opposite direction. And in reality, this gives judges a wide discretion when determining a forum dispute. One of the particular issues which arose in connection with COVID was courts in other jurisdictions being entirely closed. It was not difficult to form a case for a mother of children who were British nationals but had lived their entire lives in Vietnam, that the court here should exercise its jurisdiction on a temporary relocation because the court in Vietnam was closed. So for many of your clients and cases where we might work in conjunction with you, we should not assume that just because their children do not live here most of the time, the English court is not open to them, because in our experience, they often are.
Brilliant. Thanks very much, Jenna. So perhaps Mark, picking up on that, could you explain, please, what happens when a parent brings a child or children to the jurisdiction unlawfully or without the consent of the other parent?
Absolutely. Hello, good morning to you all, and thank you very much for joining us today. Thank you, Claire, for that warm introduction. I do have a disclaimer. I don't know about you, but during the lockdown, my children have become master hunters, seemingly able to hunt me down in any given room in my house. So I do apologise if we have some uninvited guests during this webinar. I hope that won't happen. But dealing with your question, Claire, essentially, there are basic principles that need to be established at an early stage. Number one, does the Hague Convention, 1980 Hague Convention, apply? The key to answering this question really lies in the rather vexed question of habitual residence, which, as Jenna said, is a topic all by itself. The convention will apply to any child who was habitually resident in a contracting state immediately before any breach of custody or access rights. And that's a really important term, which I'm going to deal with very briefly now. Rights of custody do not mean what it says on the tin, unfortunately. You do not have to establish that the parent has custody within the meaning of any particular domestic law. These rights are broadly construed, Claire, when considered by the courts of England and Wales. Usually rights of custody will bite with parental responsibility. Whether a parent has parental responsibility of a child, however, needs to be analysed under the law of the state where the child is habitually resident. So the important point here is just because a parent would have had parental responsibility pursuant to the law of England and Wales, that does not necessarily mean that they will hold parental responsibility under the law of the country from where the child has been unlawfully removed. And parental responsibility is just one way of establishing rights of custody, but that is one example which I use to answer that question. So once habitual residence has been established and it can be evidence that the other parent has rights of custody, the next step really is to ascertain whether the other parent was or would have been exercising those rights had the removal not taken place. And in truth, in practice, this is extremely easy to establish. So therefore, we're looking at a 2/3 point test. So firstly, a child taken from another contracting state in which they were habitually resident to this jurisdiction, and if they've left behind a parent that had rights of custody, and those rights of custody were or would have been exercised but for the removal, that child, as a matter of law, is now established as being wrongfully removed. Now, all of the listeners should note, and it's a really important point, which I'm not going to dwell on in any detail, but there is a judicial construct in England and Wales of repudiatory retention. This arises where the left behind parent agrees to a temporary removal of the child. So, for example, a holiday, which is a common temporary removal. But they agree that on the basis the child is returned, and this concept deals with what happens when that child is not returned. And frankly, I could talk for another hour on that topic, but I flag it up as a point of caution to consider in the context of there being any change of habitual residence. And even if you're acting for a client who may agree to the temporary removal of their child to England and Wales, please consider this judicial construct in our jurisdiction. Once the removal and retention has been established as unlawful, an application is normally made in England and Wales for an order to return the child. It is then open for the parent that has brought the child to England and Wales to then plead some defences under the Hague Convention. And these are typically whether the other parent has acquiesced, a child's objections to returning, and whether there's a grave risk of harm. Those, in my experience, are the most commonly advanced defences. It is important to note that the Hague Convention is applicable in the same form across all signatory states. So theoretically, it's not a matter of domestic jurisprudence. However, it should have the same meaning and effect under the laws of all of the contracting states. But I can tell all of our delegates that the courts of England and Wales have notoriously applied the Hague Convention in a very strict way, and successful defences in this country and this jurisdiction remain very rare. Always come back to the decision in Re D, where the court said the whole object of the convention is to secure the swift return of any children wrongfully removed, and I think that remains at the heart of the way our jurisdiction deals with these types of cases. However, there are tactical weapons in the armoury of a practitioner which should be deployed where a parent seeks it. For example, in a recent case where I was faced with a parent who brought a child into this country, defences, if I'm being entirely honest, looked relatively weak or on shaky grounds. We tried to steer that case into some form of cross-border mediation, lawyer-led discussions. And also, if you have the children of the right age, really, you want to try and canvass the child's views through the appointment of CAFCAS. And just on that point, going slightly off piece, but really have a look at the Supreme Court decision of Re-NY, recent decision in the context, albeit of a summary return under the inherent jurisdiction, but it implores the courts to consider the need for a CAFCAS officer to be appointed. There is a slight difference between the inherent jurisdiction and the convention, which I won't go into here, but really consider the involvement and role of CAFCAS. Now, if the court is satisfied that one of the defences relied upon has been proved to the required standard, the court here then has a discretion whether or not to return the child, and the factors to be taken into account are a 2015 decision of Re-M, which after the event, if people want us to circulate these cases, we can, and we're more than happy to do that. Finally, do not forget the impact and applicability of Brussels 2. We're still in the transitionary period. I recently acted for a parent who brought one of her children to England from Portugal. An application had already been made in Portugal, and this can mean that the courts here are bound to accede to that jurisdiction of the Brussels 2. So don't overlook that whilst we're still in this transitionary period.
Brilliant. Thank you very much, Mark. So Jenna, you mentioned in your earlier outline that one of the factors the court can consider is any discussion or agreement the parents may have had as to where any dispute might be resolved. So can parents agree how or where any dispute in relation to their children might be dealt with before that dispute arises or before court proceedings are issued?
And Claire, whilst obviously such agreements cannot protect against a parent who's determined to act unlawfully and in an abduction like Mark describes, it is possible for parents to enter into agreements as to which jurisdiction will resolve issues relating to their children before those issues arise. We see it regularly in orders that the court makes as to future disputes which might come up. One of the factors that the court must consider under this Spiliada test, which I described earlier, is any prior agreement between the parties as to where the litigation should be undertaken. And whilst that test arises out of a shipping case, or as a matter of course for agreements and contracts in relation to those types of transactions, they'll specify where any disputes will be resolved or the jurisdiction in which arbitration will take place. There's nothing to prevent parents from reaching an agreement prior, for example, to a relocation. about which court they want the decisions relating to the children to be resolved in. Trends we're seeing suggest that there is scope for a family to reach an agreement in relation to future jurisdiction for children disputes in the same way that they might in a pre or post-nuptial agreement in relation to their finances, and arguably it's our responsibility to advise on that when we're acting as trusted advisors in project managing a family's relocation, as we often do in connection with tax and trust structures. Whilst those agreements cannot be said to be entirely binding on the court, and you could never say to a client that that is going to be the end of the matter where you have an agreement, they are a conscious decision. If they are a conscious decision based on reason, that is likely to hold weight with the court. And that can work both ways for parties relocating out of England and where they are relocating into England. For example, we're working with our tax and trusts team who are managing a Middle Eastern family's relocation to England. And whilst they are choosing to relocate and educate their children here, they very much intend to maintain their lifestyle and raise their children in accordance with principles of Sharia. And they would want the court of their home country to determine any issues arising between the parents in connection with the welfare of their children. That would be a massive discussion to be had if there were to be a dispute about that in court. And it's going to be really interesting, I think, as a practitioner, to see if a jurisprudence is going to arise in relation to agreements on forum in relation to children in the same way that it has in connection with prenuptial agreements.
Great, thank you all. We're now going to move on to talk in more detail about pre and post-nuptial agreements and the factors that have to apply before an English court will consider a prenuptial agreement to be binding or to be upheld in full or in part. We're at the sharp end of that case law as it develops, both in relation to a choice of court clause and in relation to the efficacy of a prenuptial agreement in our case of BRAC. And that's a case that we've worked closely with Alex on tax issues, but also in relation to whether that prenup will be upheld and how it will be applied, the concept of needs and sharing. So perhaps if we could go into some focused discussion around that. Mark, if you could firstly perhaps help us with the key components of prenuptial agreements, what has to be considered when they're being prepared in England and Wales?
So
I think I was going to step in. Sorry, Claire. I'm happy to.
We're wrestling for space, Claire. Jenna, I'm happy to bow to you, so you can take the floor.
Beg your pardon, Jenna. You're right. That was your question. My error.
No problem at all. I don't want to have to deal with Mark's section, so I'll crack on with this one.
Absolutely.
For international families, where to have their prenuptial agreement is a legal and practical quagmire, and invariably the answer, which many of you know from the cases we work together on, is usually that they should be executed in more than one country, often a number. The prenuptial post-nuptial agreement is essentially an insurance policy, and we like to tell our clients to think of it as a travel insurance. You need to check your policy is valid depending on where in the world you might need to rely on it. Coming back to England, there's no legal requirement that the parties meet an eligibility criteria, for example, by having lived here for a specified period of time to have a prenuptial agreement here. The point at which a prenuptial agreement is made, it's a private agreement between the parties, contracting with one another about their future intentions and agreements should their marriage fail. The law in relation to prenuptial agreements in England and Wales has been relatively well settled since the case of Radmacher in 2010, where the Supreme Court said that the court should give effect to a nuptial agreement that is freely entered into by each party with a full appreciation of its implications, unless in the circumstances prevailing it would not be fair to hold the parties to the agreement. The Law Commission report following that in 2014, Matrimonial Property Needs and Agreements, recommended legislative reform to make nuptial agreements which meet a criteria legally binding or qualifying. And then the Divorce Financial Provision Bill a little controversial, it's been debated recently, is also looking to provide legislative backing to make qualifying pre- and post-nuptial agreements binding. Whilst neither have been enshrined in law to date, the Law Commission recommendations is the checklist by which most practitioners will abide by when advising on a prenuptial agreement. So a quick summary of the criteria which was proposed by the Law Commission. Agreements should be entered into of free will, so there must be no duress or misrepresentation in negotiating or executing that agreement. It's got to be validly executed as a deed where the parties are signing that they acknowledge the effect of the agreement that they're entering into. It should be made not less than 28 days before the wedding, and if they're not going to sign it within 28 days before, we would be advising a client to enter into a post-nuptial agreement in mirror terms after the wedding too, and to express in their prenuptial agreement that that is their intention to have a post-nuptial agreement too. The parties should have received disclosure of material information about one another's financial situations. They should be legally advised, and it should meet the needs of the parties and not prejudice any children. If it's manifestly unfair, the courts are probably going to depart from it on some level. Each of those categories is a topic in its own right, which we don't have time to delve into today, although Mark, I think, is going to expand on some of the more salient points as to enforceability shortly. So Claire, you did ask about the disclosure requirements, and we would always encourage clients to give and provide the other party with a full disclosure of their worldwide assets. There are instances where parties agree not to go beyond a schedule of assets, income and liabilities, which gives an overall summary of that party's financial circumstances. But in other cases, it might require a full disclosure, and you might want it verified by a statement of truth, which you can rely on later. It is, however, important in either case that this disclosure covers all assets in all jurisdictions, so that the other party can be considered to have had all material knowledge at the time of entering into the agreement. And it is important to get the disclosure aspect right, because that's one of the first things that a lawyer wanting to get their client out of a prenuptial agreement will look at critically. It isn't automatically a ground to invalidate a prenuptial agreement if there hasn't been disclosure, but it's certainly going to give somebody an in. In Radmacher, the wife, who was the financially stronger party in that case, gave no disclosure of her wealth at the time of the prenuptial agreement. And whilst the husband didn't challenge that at the time, he did in subsequent divorce proceedings. But in that case, it was not held to invalidate the agreement. The question really is whether there has been material non-disclosure or misrepresentation of assets. And the principles relating to set aside for misrepresentation were considered by the Supreme Court in our case of Charland in 2015, where we acted for the wife, the husband, who'd been less than frank in his disclosure within the divorce proceedings. Those principles are instructive in connection with misrepresentation of assets in connection with the prenuptial agreement too.
Great, thank you, Jenna. And you're absolutely right, Mark. You were going to share with our guests this morning your experience of what effect a non-UK prenup has in the UK.
Thanks, Claire. I'm happy to take the floor on this one. This is a really interesting question actually at the moment, and it is a hot topic. We live in a truly global world at the moment. It's more necessary than ever to advise in cross-border disputes, especially as prenuptial agreements are enforceable in various European and non-European countries. So what happens really is a question as to when a party or a client brings a prenuptial agreement signed and executed by both parties from another jurisdiction, and they bring it to us in England and Wales. What happens? Well, if English law, if the Court of England and Wales is to seize jurisdiction of the case, then English law will apply. This is absolutely regardless of whether it's a foreign prenuptial agreement. So that's the first basic point to note. As Jenna said, the seminal authority is Radmacher, which everybody knows now. That settled the law in terms of the approach of prenuptial agreements. But interestingly, Radmacher also dealt with briefly the foreign element. In that case, the husband was French and the wife was German, and the agreement had a German law clause. So the court set out, and I'm sorry to quote the passage here from the case, and as I say, we can circulate these, but I think it's important to note that the court said, Foreign elements, such as those in this case, may bear on the important question of whether or not the parties intended their agreement to be effective. They then go on to say that in summary, the issues in the case are governed exclusively by English law. The relevance of German law and the German choice of law clause is that clearly they demonstrate the intention of the parties that the anti-nuptial agreement should, if possible, be binding on them. That approach was reaffirmed by a decision in 2013 of Mr. Justice Moore, the PH. But in summary, English law will apply to the weight to which the court will attach to a foreign prenuptial agreement. However, the intention of the parties when they entered into the foreign agreement will be relevant. In cases of this nature, and I've got a particularly contentious case at the moment involving a South African prenuptial agreement. As a matter of course, we would apply, as we have in that case, to obtain a legal opinion from a specialist family lawyer in South Africa or in the jurisdiction where the anti-nuptial agreement was formed. This, in my view, it's only my opinion, but it's more important than ever to adopt that approach, especially following the decision of Mr. Justice Mostyn in the recent case of Ipeki, where the court actually attached zero weight to an agreement formed in New York. And the reason for that is because it suffered from a fatal defect under the laws of that state. And effectively what the court said in layman's terms is, you've made your bed in New York and now you must lie in it in England. And I think that's an important decision. So consideration should always be given to the scope of the instruction to the foreign lawyer, to include commentary as to whether the prenuptial agreement is first and foremost valid in that country, and the way in which the advice was given, and try and assess the attention of the parties is really what you're trying to drive at. Obviously, this is always subject to needs, so you can drive a coach and horses through these arguments, often through needs arguments. But obviously, if we're acting for the party seeking to rely on the foreign prenuptial agreement, we need to be considering all of the evidence. In my experience, from a very early stage, you need to be making inquiries to obtain the file of the solicitors where the agreement was drawn up, identify which lawyer it was, try and find emails between the parties. Really drilling into the evidential and factual matrix of any of these cases is super important. So therefore, in summary, an agreement entered into in another jurisdiction should certainly not be discounted, in my view, in terms of the weight attached to it in this jurisdiction.
Great, thank you. Moving on now to start to address some of the trust-related matters, Mark. To what extent does a beneficiary or a settler of a non-UK trust, for example, have to disclose what's in the trust, what the terms are, especially if they're only one member of the class of beneficiaries? We often see that sort of caveat raised, but could you talk us through some of those issues?
Absolutely. I'm conscious also, in typical lawyer style, we are slightly short on time, and I know that Alex follows me with various interesting topics. You know, Claire, this is a particular hobby of mine, international and overseas trust, and I could probably talk forever. But I'm just going to briefly, if I can, answer this question. It depends really on whether the beneficiary and settler are one and the same, and various other aspects, including the location of the trust and the nature of the document. So the starting point, and this is very much a starting point, is that a party to the proceedings has a duty of full and frank disclosure. Beneficiaries have a right to documentation regarding trusts. However, disclosure of documentation is a matter for the trustees exercising their discretion, and that's an important point to note. And you really need to have a look at who the trustees are, whether they're professional trustees, where they're located. And I could go on and talk about all kinds of different arguments that are raised in these cases. For example, the phrase coined about dear me trusts, those types of issues, which all rear their heads in these types of cases. But because we're short on time, Claire, I'm just going to focus on, for example, the letters of wishes. This document is a really important document. It offers a roadmap, really, of the intentions of the trustees, which, from an evidential perspective, obvious reasons, what the trustees intended, or how they intended their discretion to be exercised can often be an extremely valuable document to one of the spouses. But when arguing disclosure of letters of wishes, really I would urge practitioners to draw a distinction between, for example, letters of wishes and meeting minutes, advices with the professional trustees or their lawyers, and really draw a distinction between those documents and documents such as deeds, trust deeds and accounts. Now, in terms of the latter, it's very likely there's a presumption in favour of those being disclosed, and it's very likely in all of the cases that you will obtain those. But don't rule out arguing against disclosure of the letter of wishes. It is very fact specific and case specific, but there is a Privy Council decision actually of Schmidt and Rosewood Trust Limited in 2003, and that's a really useful authority for those practitioners seeking to argue against disclosure of a letter of wishes. So really have a look at that. In my experience, that's a really important battle line to draw at an early stage if it's necessary. However, talking generally, in my experience, trustees are unlikely to disclose fully unredacted letters of wishes. Depends what jurisdiction you're in. At the moment, I'm having a nightmare trying to get documents from Gibraltar, but for example, I found Isle of Man more open to dialogue. So it does depend, but my big practical point there would be draw a distinction between the types of documents that are being sought and really give some careful consideration to that point.
Brilliant, thank you. We have had a couple of questions about prenups, but perhaps before we go on to address those, because it's relevant to the question of trust assets in prenups. Perhaps we could move on to Alex now, please, to talk more from a tax and trust specialist point of view. One of the issues we had in a recent case, which Alex is going to share with you, is how a non-UK trust could be split and whether there were any UK tax consequences that can be mitigated by planning ahead, and the concept of short-term and longer-term measures, and the interplay between tax and family law. So Alex, perhaps I could turn to you, please, to talk about the possibility of splitting trust assets and the tax consequences you might be typically called to advise upon.
Yes, thanks very much, Claire. Yeah, I'm in the tax, trust and estates team. So this is my thing, and I often work with the family team. Usually because where you have, or very commonly where you have UK residents who have an international background, there may very well be a trust involved, either one that they have created themselves or that has been created by another member of the family. Those trusts often hold a substantial amount of money or assets, and therefore it's quite common for them to be factored in or integrated into any financial arrangements between the divorcing parties. As Mark and Jenna can say, often that's the subject of some discussion and dispute, but equally where an arrangement can be reached more amicably, a trust is often part of the deal. There are two common arrangements we see in relation to non-UK trusts. The first one is where the trustees actually appoint assets outright to one of the parties to the marriage or to the children. The second is where the trust is divided into one or more parts. So you might have one part that's designated to benefit one member of the one party to the marriage, and another part for the other party. The reason I talk about tax is partly because I'm a tax lawyer, but also because where you have UK resident beneficiaries of non-UK trusts, anything where the trust is used to benefit them or could be used to benefit from them can have quite substantial tax effects, and that must be factored in because, for example, the top rate of UK income tax is 45%. So if the tax is not factored in from the very start of any financial arrangements involving trusts, it might mean that one party ends up with considerably less than they anticipated, and that might lead, or we've certainly seen that lead to discussions having to be reopened at a very late stage. Everyone thinks they've got to an agreement, someone looks at the tax, and then everything starts all over again. So I'm going to talk first about what happens where there's an appointment of assets outright to a UK resident beneficiary from a non-UK trust. The way it usually works is, well, the way that the UK taxes trusts is that where you have non-UK resident beneficiaries, sorry, non-UK resident trustees, those trustees are outside the territorial scope of UK tax. So the way that the UK tax system works is to try and recoup tax, so that when a beneficiary of the trust receives a distribution from that trust, the UK tax system then kicks in and tries to get tax from that beneficiary. I don't want to bore you all to death or confuse matters by going through the tax law minutely, but it might help, I think, to understand if I just describe the key points of taxation of trusts in these kinds of circumstances. So there's a slightly different regime depending upon whether the person who's receiving assets from the trust is the settlor, so the person who funded the trust, or the beneficiary only. If you have a settlor who is UK resident and domiciled, and they are receiving assets from a trust, or in fact, even if they're not receiving assets from a trust, the income and gains of the trust are generally taxed on them. There's a kind of look through. This happened to a client of mine. He had been resident and domiciled in Switzerland and set up a trust, and then he came back to the UK and he was deemed to be resident and domiciled here. He was therefore taxed on all the income and gains that the trust made. And the reason that mattered in his case was that part of his divorce settlement was that his wife would receive assets from the trust. There was a property that was appointed to her. That appointment realised the gain on the property, and because he was the settlor of the trust and because he was UK resident and domiciled here, he actually had to pay the tax on the gain that was realised, and that had to be factored in to the calculation of what they were both going to receive. So if she got the asset, he paid the tax. For beneficiaries, the rules are different. So these are beneficiaries who haven't actually contributed to the trust. The way it works is that the income and capital gains that the trust has made over the years are calculated. And the income is generally called relevant income, and it's income that could be used to benefit the beneficiary. And the gains are generally called trust gains. So you have a calculation of relevant income and trust gains. And when a beneficiary receives a distribution from the trust, you look at the value of that distribution, and you look at whether or not the income, first of all, whether the income covers the value of that distribution. And if it does, then the distribution is treated as income in the hands of the beneficiary. So it's probably best to explain this by way of an example. So you might have a trust that was set up by husband's grandmother, and over the years that trust has made £500,000 worth of relevant income. So that's income that could be used to benefit the beneficiaries. Husband then receives a distribution of £800,000 from the trust. So the trust has made £500,000 of income. Husband has received £800,000 worth of assets from the trust. Husband is treated as if £500,000 worth of what he's got is income. So the income is matched up with the distribution, and there's £500,000 worth of income in the hands of the husband. So there's another £300,000 which hasn't been matched to income. That is matched up with the trust gains. So if the trust had made, say, £400,000 worth of gains over the years, husband would be treated as if he'd received £500,000 worth of income and £300,000 worth of capital gains. What that means then is that you have to look at the husband's own taxation. So he's received income and gains, and they are taxed in the UK according to his own tax status. So that means things like his own marginal rates, up to 45% tax on the income, and in terms of the capital gains, the normal rate is 20%, But if some of the gains in the trust are very old, so more than 2 years old, that rate can actually go up to 32%. In some cases, we have parties who are UK domiciled, but they claim the remittance basis. So that means that if they receive a distribution of non-UK assets from a trust, they don't have to pay tax on them until they actually bring them to the UK. I'm going to talk about how that can be integrated into divorce planning in a minute, because it can be quite useful. One thing I would say is I've talked about where there is a distribution to one beneficiary. Obviously, sometimes there can be distributions of assets to several beneficiaries of a trust, husband and wife or civil partners, as part of a divorce. In my experience, it's important generally that those distributions happen in the same tax year. And the reason for that is to make sure that the income and gains are split proportionately between the two distributions, so that one beneficiary isn't paying lots of tax and the other one paying very little. So that's just a point to remember. Timing is important. It's also very important to get all the facts about the trust up front. So to get calculations of the income and gains done and an idea of what tax is going to be paid before going too far with negotiations that might involve the trust. Because as I say, sometimes people can get a nasty surprise when the tax is actually analysed, and it means going back and starting to recalculate. I've talked about outright distributions to beneficiaries. Sometimes you have a split of trusts, so a trust will continue, but it will be divided into two separate funds. If that happens, there's no immediate tax liability, because if it's done right, no beneficiary should actually be getting anything from the trust at that point, so there's nothing to tax. But there are longer term considerations there, and they probably, I suppose, relate to what I've just talked about, so the relevant income and gains pools, and how a beneficiary receiving a distribution will have to match that distribution to income and gains that the trust has made. Again, it's probably easiest to explain this by way of an example, and this is a case I've recently been dealing with, where there is a trust in Jersey and it's being divided into two parts. In this case, we have one part which is for husband and children, and the other part is for wife. So the beneficiaries are named as those people in the trust deed that's splitting the trust into two bits. What we pointed out was that if we had a situation where, for example, wife received a benefit from her part, we would have to look at what the relevant income of the trust was, and if the relevant income covered her distribution, she would have to pay UK income tax on her distribution. So the question was, well, what is the amount of relevant income here? And because of the way that the trustee or the split had been drafted, the relevant income in relation to the wife was going to be all the income that arose on the original trust before it was split, and this is where it got a bit odd, the income that arose on the husband's part of the trust as well. And the reason for that was that wife hadn't been excluded as a beneficiary of husband's part, and therefore HMRC were likely to take a view that all the income of the husband's part could also be taxed on wife if she received a distribution. That's obviously not what was intended, so unfortunately things hadn't gone too far and we were able to rectify it. But it's an example of how it's really important to look very carefully and think about what's going to happen after the divorce. You can otherwise have a hangover of tax for one beneficiary and when they didn't expect it. I think also in that case we looked at whether or not the actual wife should have a whole new trust, so actually splitting and keeping one single trustee with two separate funds probably wasn't the best idea. And I think what we're going to do is actually set up a completely new trust for wife to completely separate her bit from the husband and children's bit, which should work. There are also other things you can do with trust. I mean, what we often get asked about is where perhaps there is a trust and one party says, can I receive a distribution from that trust and then give it to the other party as part of the divorce arrangement. And there were some rules that came in 2018, which were called the onward gifting rules, which everyone was quite concerned about, because what they said was that if somebody receives a distribution from a trust and doesn't pay tax on it, for example, because they're not resident in the UK, and then they give the money that they've received to a UK resident, there's a kind of look through that the middle stage is ignored, and it's as if the UK resident has received the distribution directly from the trust, and that means that the sort of ultimate recipient of the money has to pay tax on it. The general view is that these onward gifting rules don't apply in the context of a divorce. So in other words, if a husband receives a distribution from a trust on which he doesn't have to pay tax and he gives it to wife, the onward gifting rules don't apply. And the reason that's important, or the reason that can be useful, is that where you have a situation where you have perhaps a party to a marriage who is going to go abroad and become non-resident after the divorce, and again that's not unusual in my experience, what they might do is take a distribution from a trust once they've become non-resident, and then give it to the spouse in the UK. Because they're non-resident, there's no tax when first spouse receives the distribution from the trust, and when they make a gift to their spouse, a gift isn't taxable, or a transfer isn't taxable, and therefore the spouse in the UK receives that payment tax-free. Sometimes people don't become non-resident, but you do have parties, particularly non-domiciled individuals, who will often claim the remittance basis of taxation, and what that means is that they're not taxed on their foreign income and gains. So again, I did this actually with a client a couple of years ago. He was UK resident but claiming the remittance basis. He received a very substantial distribution from a trust. He left that offshore, and then once the decree absolute had come through, he transferred that money to his spouse, and that was a very tax efficient way of extracting money from the trust and getting it to the spouse in order to settle the financial, make the financial settlement between them. So I would say that's often quite a good strategy. One thing to bear in mind is that although we think the onward gifting rules don't apply, and that's a sort of the general viewing authoritative commentary, we haven't actually had a tax case about it yet, so it is untested in the courts, and also I think it needs to be done pursuant to a court order. So in other words, you should have a consent order or other things of which I'm not aware because I'm not a matrimonial lawyer, but a court order that orders the payment of the money received by the trust beneficiary to the other spouse, so that in other words what you have is not a gift but actually something to satisfy the court. Finally, we often get asked about children, so using a trust to support children. The most common arrangement is where it is agreed that a trust, an existing trust, should be used to pay school fees because they tend to be the biggest single expense in relation to children. The actual sort of method of taxation will depend entirely upon things like where the trust is, who set it up, etc., etc. But the bottom line is that in almost all cases where there's a distribution to pay school fees, or a direct payment even from the trust to the school to pay the school fees, it's the parent who will have to pay tax on that distribution if they're UK resident. There is an exception to that, so where you have a non-UK trust that is funded by someone other than the parent, it is possible to minimise the risk that the payment will be taxed on the parent by ensuring that the trustees contract directly with the school. And the reason for that is that HMRC's general view is that where a trust is paying school fees, the benefit is actually the parent's benefit, because the trust is taking on the liability of the parent, and therefore the parent is getting the benefit and should be taxed according to the rules that I've previously described. You can get round that, or try to get round that, by the trustees actually signing up directly with the school and taking the liability for school fees upon themselves. And then it's possible to argue that it's not the parent's liability that's being discharged. As I say, it's something where I think HMRC might challenge it, but it's definitely a possibility. Also, just bear in mind that if that is happening, so if that method is used, there is still a benefit going to the children, so not to the parent, but to the children. The children may have to complete their own tax return and pay tax, but generally that tax is going to be a lot lower because the children aren't working, generally have things like their personal allowances and lower rate tax bands available. So that is a very quick run through of trust in the context of divorce. I've tried to keep it as non-overly technical as possible, but there may very well be questions that come out of that. So I'm going to hand back to you, Claire.
Okay, thank you. Thanks, Alex. Right, conscious of the time, we have had a number of questions. We've got 5 minutes, so I'm going to pull one question out, if I can, for each of you, and you've got a minute to to answer it in. Okay, let's start with you, Mark. I don't know who the question's from, but it's picking up on the point you made about different jurisdictions receiving requests for information in relation to trusts differently, and just to elaborate on that if you can, and what tricks you've deployed to try and get information where you've had resistance. Thank you.
Yeah, I think it's very fact specific and very case specific, Claire. Essentially, there are some jurisdictions who if I can put it this way, do tend to adopt a more robust approach than others. But I think the key really is to identify to what extent your client or perhaps the opposing party has control over what comes out of the trust. The particular case I'm acting at the moment involves trusts around the world, but one in particular in Gibraltar, and my client genuinely has very limited control or power over that trust and knows very little about it. So in those circumstances, the professional trustees can adopt quite a firm stance in terms of what they disclose. Now, if you're acting for the opponent or the opposing party, there are some practical weapons available to you. So, for example, there is a bit of academic debate about whether trustees should be joined into proceedings. The view really is that my view really is that it's not justified to join in trustees if it's for the purposes of obtaining information, because there are two other routes available, and I'll deal with this in 10 seconds. There's an application for third-party disclosure which can be made under Rule 21.2. Sorry if I got that completely wrong. And secondly, orders can be made in personam against the other party, and so if you apply enough pressure, in my view, it's not always necessary to adopt the nuclear approach of joining the trustees or going into those jurisdictions to have those arguments.
Brilliant, thank you very much, Mark. Alex, we've had a question from Rhiannon. Thank you, Rhiannon, for posing this. Do the onward gifting rules apply to real property being distributed from a trust, or just income and capital?
They do apply to real property. So you might have a situation where Mr. X lives abroad and he receives a distribution of a trust asset. So, for example, maybe a house in the UK, even if there's any still left in trust, and then he gives that to his soon-to-be ex, Mrs. X, and the onward gifting rules, if they applied, would say Mrs. X had received that real property direct from the trustees and would probably have to pay tax on the distribution to her. If, as I say, this is done, or the transfer is done pursuant to a court order, then it's probably possible to argue that the onward gifting rules don't apply. So Mr. X has received the real property. He's got it tax-free because he's non-resident, although the trustees might have had to pay some tax. and then he's given it to Mrs. Y, and she's received it tax-free because it's not income or gains that she's received. She's just received an asset from her former husband. So they do apply, but again, the sort of rule that stops the onward gifting rules applying in a situation where there's a divorce and a court order also apply. So you can use the sort of same methods as you would use just for a distribution of cash. Obviously it's more complicated that because it's tax, but that's basically the answer.
Brilliant, thanks Alex. Hope that answers your question, Rhiannon. If it doesn't, or you need further information, please feel free to contact Alex direct. I'm glad we can kick that into your court, Alex, and we as family lawyers don't have to deal with that. Right, I'm conscious it's 9 o'clock. We have had a couple of questions about, which I was going to put to Jenna, about what happens if prenups don't meet needs. That's a whole nother topic in its own. More than happy to deliver another session on that if people would find that helpful. So we have asked you to complete the feedback form that can be found in the Q&A section of the webinar, and please feel free to post any further questions through that virtual hub and we will try and get back to you. We hope you found that useful. Please keep the questions and dialogue going. We've thoroughly enjoyed the opportunity to interact with you. More than happy to deliver any other sessions if you think that would be helpful. Please complete the survey. Stay safe. Hope to see you all soon, and thank you very much for joining us. Have a great day. Bye bye.